Hello, I am Judge Jessica Costello. I serve as a judge in the 13th Circuit of Florida, which covers Hillsborough County. One of my primary responsibilities is serving as a judge who presides over domestic violence injunction matters. And I'd like to discuss the domestic violence injunction process with you today. Pursuant to Florida statutes, an individual who is or believes that they may be a victim of domestic violence, sexual violence, dating violence, repeat violence, or stalking may file what's called a petition to the court requesting the issuance of a temporary injunction for their protection. A judge like myself then reviews the petition and makes a determination as to whether or not the allegations contained in it meet the requirements of Florida law. And if so, the judge grants the temporary injunction. A temporary injunction prevents a respondent, the person against whom the injunction is issued, from being within a certain amount of feet of a petitioner's residence, or a petitioner's place of work. The court may also impose additional restrictions based upon the specific facts alleged in the petition, including making determinations related to the safety and well-being of any children that the parties may have in common. Pursuant to Florida law, within 15 days of the issuance of a temporary injunction, a hearing must be held in front of a judge to formally address the allegations of the petition. At that time, a judge will take testimony, hear from witnesses, and consider evidence, ultimately making a decision as to whether a final injunction for protection should or should not be issued. During that time, judges do their best to ensure all of the parties have an opportunity to be heard if they wish, and to have as full of an understanding of the facts as possible such that a fair decision can be made. This is a brief overview of the domestic violence injunction process. Thank you for taking the time to learn a little bit more about this process today.